The difference between Rule 45 and Rule 65. Rule 45 is called the appeal by certiorari to the Supreme Court. A petition for review on certiorari, also known as appeal Supreme Court, from a judgment or final order of by certiorari is a mode of appeal to the number 1, Court of Appeals, Sandigan Bayan, Regional Trial Court, where the appeal raises only questions of law, Court of Tax Appeals and Bank, Section 19 RA 1125 as amended by RA 9282. Number 5, Court of Appeals, Sandigan Bayan and Regional Trial Court in a writ of amparo or writ of habeas data. Section 19 Rule on the writ of amparo, Section 19 Rule on the writ of habeas data. It is initiated by the filing of a verified petition. Note that an appeal to the Supreme Court may be taken only by a petition for review on certiorari, except in criminal cases where the penalty imposed is reclusion perpetua or life imprisonment, Section 3 of Rule 56. A judgment imposing the death penalty is subject to automatic review. May a petition for review on certiorari raise questions of fact? Generally, no. Rule 45, Section 1 states that the petition shall raise only questions of law which must be distinct set forth. The exception wherein the petition may raise questions of fact are, number 1, an appeal from a final judgment or order in a writ of amparo or writ of habeas data case may be taken to the Supreme Court under Rule 45. The appeal may raise questions of fact or law, or both. Section 19 Rule on the writ of amparo, Section 19 on the writ of habeas data. Number 2, when the conclusion is grounded entirely on speculation. Number 3, the inference is manifestly mistaken, absurd, or impossible. Number 4, there is a grave abuse of discretion. Number 5, the judgment is based on a misapprehension of facts. Number 6, the findings of facts are conflicting. 7, the Court of Appeals in making its findings went beyond the issues of the case, and the same is contrary to the admissions of both appellant and appellee. 8, the findings are contrary to those of the trial court. 9, the findings of fact are conclusions without citations of specific evidence on which they are based. 10, the facts set forth in the petition as well as in the petitioner's main and replies brief are not disputed by the respondents. 11, the findings of fact of the Court of Appeals are premised on the supposed absence of evidence and contradicted by the evidence on record. So, distinguish a petition for review on certiorari from a special civil action for certiorari. As to governing rule, a petition for review on certiorari is governed by Rule 45, while a special civil action for certiorari is governed by Rule 65. As to nature of proceeding, a petition for review on certiorari is a mode of appeal, while a special civil action for certiorari is an original action. As to jurisdiction, a petition for review on certiorari is under the exclusive appellate jurisdiction of the Supreme Court, while a special civil action for certiorari is under the concurrent original jurisdiction of the Supreme Court, the Court of Appeals, and the Regional Trial Court, Sandigan Bayan and Comelec. As to requirement of a motion for reconsideration, a petition for review on certiorari does not require the filing of a motion for reconsideration with the lower court, while the filing of a motion for reconsideration is a condition precedent to the filing of a special civil action for certiorari. As to reglementary period, a petition for review on certiorari should be filed within 15 days from notice of the judgment or final order being appealed from, while a special civil action for certiorari should be filed within 60 days from notice of the judgment, order, or resolution. As to findings of facts of the Court of Appeals are binding upon the Supreme Court in a petition for review on certiorari, while in a special civil action for certiorari, the findings of fact of the Court of Appeals are not binding. As to impleading of parties, in appeal by certiorari, the lower courts or judges are whose decisions are subject of review are not impleaded either as petitioner or respondents, while in a special civil action for certiorari, the lower court or judges whose orders or proceedings are subject to challenge are impleaded as public respondents. What is the remedy from a decision or final order issued by the Court of Appeals in a petition for freeze order filed by the Anti-Money Laundering Council? A petition for review on certiorari to the Supreme Court under Rule 45. Any party aggrieved by the decision or ruling of the court may appeal to the Supreme Court by petitioner for review on certiorari under Rule 45 of the Rules of Court. The appeal shall not stay the enforcement of the subject decision or final order unless the Supreme Court directs otherwise. Section 57 AM number 05-1104, Supreme Court, effective December 15, 2005. So within what time may a petition for review on certiorari be filed? Again, the petition shall be filed within 15 days from the notice of the judgment or final order or resolution appealed from, or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment. On motion duly filed and served, with full payment of the docket and other lawful fees and deposit for costs before the expiration of the reglementary period, the Supreme Court may, for justifiable reasons, grant an extension of 30 days only within which to file the petition. In an appeal from a writ of amparo or writ of habeas data case, the appeal period is 5 working days from the date of notice of the adverse judgment or order. Section 19, Rule on the writ of amparo. Section 19, Rule on the writ of habeas data. Example: P received an adverse decision on the CA on 2 September 2005. P thus had until 19 September 2005 within which to file his petition for review on certiorari, since September 17, 2005 was a Saturday. On September 16, 2005, P filed a motion for a 30-day extension to file his petition. The same was granted by the Supreme Court. Up to when may P file the petition? Up to October 17, 2005. AM number 00214 SC provides any extension of time granted by a court should be computed from the expiration of the original period, regardless of the fact that said expiry date falls on a Saturday, Sunday, or legal holiday. Hence, the 30-day extension should be reckoned from September 17 and not 19. What should be the contents of a petition for review on certiorari? The petition shall state the full name of the appealing party as the petitioner and the adverse party as the respondent, without impleading the lower court or judges thereof, either as petitioners or respondents. Number 2, indicate the material dates when notice of the judgment or final order or resolution subject thereof was received, when a motion for new trial or reconsideration, if any, was filed, and when notice of the denial thereof was received. 3, set forth concisely a statement of the matters involved and the reasons or arguments relied upon or relied on for the allowance of the petition. 4, be accompanied by a clearly legible duplicate original or a certified true copy of the judgment or final order or resolution certified by the clerk of court of the court or co, and the requisite number of plain copies thereof, and such material portions of the record as would support the petitions. 5, contain a sworn certification against form shopping as provided in Section 242. Section 2, Rule 45. Proof of service of a copy of the petition in the lower court concerned and on the adverse party shall be submitted together with the petition. That is in Section 3, Rule 45. What are the grounds for the outright dismissal or denial of the petition? Failure of the petitioner to comply with the requirements regarding payment of the docket and other lawful fees, deposit for costs, proof of service of the petition, and the contents of the document which should accompany the petition shall be a sufficient ground for the dismissal thereof. Hence, a petition which is not verified or which contains a defective verification may be dismissed outright. Number two, the Supreme Court may on its own initiative deny the petition on the ground that the appeal is without merit, or is prosecuted manifestly for delay, or that the questions raised therein are too unsubstantial to require consideration. This is because review under Rule 45 is not a matter of right, but of sound judicial discretion, granted only when there are special and important reasons. Therefore, is Rule 45 applicable for both civil and criminal cases? Yes. The mode of appeal prescribed in Rule 45 shall be applicable to both civil and criminal cases, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment. Hence, if the judgment of the Court of Appeals or the Sandiganbayan imposes the penalty of reclusion perpetua or life imprisonment, appeal shall be taken by filing a notice of appeal. If the Court of Appeals or Sandiganbayan imposes the death penalty, the same shall be automatically reviewed by the Supreme Court. 65 is special civil actions for certiorari, prohibition, and mandamus, which court has jurisdiction over the special civil action for certiorari, prohibition, and mandamus. There is concurrent original jurisdiction among the Supreme Court, Court of Appeals, the regional trial courts, and the Sandiganbayan and the COMELEC. In City of Manila versus Grecia Cuedo, February 4, 2014, the Supreme Court held that it is the Court of Tax Appeals, not the Court of Appeals, which has jurisdiction over a special civil action for certiorari, assailing an interlocutory order issued by the RTC in a local tax case, since such a case falls within the CDA's exclusive appellate jurisdiction. So does it mean then that a person has an unfettered discretion to choose which among the aforesaid courts he may file the special civil action under 65? No. The concurrence of jurisdiction should not be taken to mean that the parties have an absolute unrestrained freedom of choice of the court to which they will file their application for petition. There is an ordained sequence of recourse to courts vested with concurrent jurisdiction beginning from the lowest to the highest. This hierarchy is determinative of the venue of appeals and is likewise determinative of the proper form for petitions for extraordinary writs. A direct invocation of the Supreme Court's original jurisdiction to issue these writs should be allowed only when there is or there are special and important reasons thereof, clearly and specifically set out in the petition. Montes versus Court of Appeals, GR 143797. This is known as the principle of doctrine of hierarchy of courts. Case example. On December 15, 2014, the Department of Transportation and Communication, DOTC, and its attached agency, the Civil Aviation Authority of the Philippines, CAAP, posted an invitation to pre-qualify and bid invitation of the airport development, operations, and maintenance of the Bacolod Silay, Davao Iloilo, Laguindingan, Nubo Hall, Panglao, and Puerto Princesa airports collectively projects. On March 10, 2015, the DOTC and the CAAP issued the instructions to prospective bidders, or ITPB, which provided that prospective bidders are to pre-qualify and bid for the development, operations, and maintenance of the airports, which are now bundled into two groups. Collectively, the bundled projects, namely Bundle 1, Bacolod, Silay, and Iloilo, and Bundle 2, Davao, Laguindingan, and Nubo Hall. The cost of Bundle 1 and Bundle 2 are 50.66 billion and 59.66 billion, respectively. The Puerto Princesa Airport project was not included in the bundling. On March 27, 2015, petitioner GOIS Samar Incorporated, suing as a taxpayer and invoking the transcendental importance of the issue, filed a petition for prohibition with the Supreme Court. Petitioner argues that the bundling of the project is unconstitutional because it will, number one, create a monopoly, number two, allow the creation and operation of a combination in restraint of trade, three, violative or violate anti-dummy laws and statutes giving citizens the opportunity to invest in public utilities, and number four, enable companies with shaky financial backgrounds to participate in the projects. Was the filing of the petition for prohibition with the Supreme Court proper? Unfortunately, the Supreme Court said no. While the Supreme Court has original and concurrent jurisdiction over petitions for certiorari, prohibition, and mandamus, with other courts, litigants do not have unfettered discretion to invoke the Supreme Court's original jurisdiction. The doctrine of hierarchy of courts dictates that direct recourse to this court is allowed only to resolve questions of law, notwithstanding the invocation of paramount of transcendental importance of the action. This doctrine is not mere policy, rather it is a constitutional filtering mechanism designed to enable the court to focus on the more fundamental and essential tasks assigned to it by the highest law of the land. Petitioners' arguments against the constitutionality of the building of the projects are inextricably intertwined with underlying questions of fact, the determination of which require the reception of evidence. The Supreme Court, however, is not a trier of facts. It cannot resolve these factual issues at the first instance, hence the petition should be dismissed. GIOS Summer versus DOTC, February 12, 2019. Section 1. What is petition for certiorari? It is a special civil action of certiorari. It's an ordinary remedy by which an aggrieved person prays for a judgment annulling or modifying the proceedings of a tribunal, board of officer exercising judicial or quasi functions, on the ground that such tribunal, board of officer has acted without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to lack of or excess of jurisdiction. So what does without jurisdiction mean? It refers to a case where the court or quasi-court does not have subject matter jurisdiction over the case or dispute. How about excess of jurisdiction? It refers to a case where the court of quasi-court has subject matter jurisdiction, but it issues an order which has no power or which is beyond its power to do so. For instance, the RTC of Manila issues a preliminary injunction seeking to restrain a person in Batangas from performing a practical act. So what is grave of abuse of discretion? That it's amounting to lack or excess of jurisdiction. When a court or quasi-court abuses its discretion in a manner which is so patent and gross as to amount to an evasion of positive duty or to virtual refusal to perform a duty enjoined by law or to act at all in the contemplation of law. For instance, a court grants a motion for preliminary attachment on the sole ground that the defendant is in imminent danger of insolvency. So may an administrative agency like the Department of Agrarian Reform Adjudication Board issues with writ of certiorari? No, administrative agencies such as Department of Agency, Agrarian Reform Adjudication Board or DARAB are not courts of law exercising judicial review or judicial power. The power to issue writs of certiorari is an incident of judicial review. Thus, administrative agencies may not issue writs of certiorari to annul acts of officers or state organs even when they exercise supervisory authority over these officers or organs. Solera versus Land Bank, number 9, 2000, August 9, 2017. Petitioners who are complainants before the prosecutor's office in Davao filed a petition for certiorari prohibition and mandamus against the Secretary of Justice to set aside the issuance of a department order which directed all prosecutors to forward all cases already filed against Celso de Los Angeles of the Legacy Group of the Secretariat of the special panel created by the Department of Justice in Manila. Was the filing of the petition proper? No. Petitions for certiorari and prohibition are directed only to tribunals that exercise judicial or quasi-judicial functions. The issuance of the department order was a purely administrative or executive function of the Secretary of Justice, nor is mandamus proper to control or review the exercise of discretion. Ducadao versus Secretary of Justice. Is a special civil action for certiorari against the Secretary of Finance and the Commissioner of Internal Revenue proper in order to set aside the BIR's Revenue Regulation Number 2, 2012, which imposed value-added taxes on the importation of petroleum into the free port and special economic zones? The answer is no. Respondents do not fall within the ambit of a tribunal, board, or officer exercising judicial or quasi-judicial functions. They issued RR 2, 2012 in the exercise of their quasi-legislative or rule-making powers and not judicial or quasi-judicial functions. Respondents did not adjudicate or determine the rights of the parties. Clark, Investors and Locators Association versus Secretary of Finance, 2015, July 6. The Energy Regulatory Commission, or ERC, issued the rules for setting the electric cooperatives wheeling rates, or RSEC-WR, and Resolution Number 14, which set the electric cooperatives wheeling rates and allowed electric cooperatives to collect contributions from members for capital contributions. The petitioner who are members of electric cooperatives filed a special civil action for certiorari with the Supreme Court to set aside Resolution Number 14. Was the resort to a special civil action for certiorari proper? The answer is no. The ERC did not exercise judicial or quasi-judicial functions in issuing and implementing the RSEC-WR and Resolution Number 14. It was not called upon to adjudicate the rights of contending parties or to exercise in any manner discretion of a judicial or quasi-judicial nature. Instead, RSEC-WR and Resolution Number 14 were done in the exercise of the ERC's quasi-legislative and administrative functions. It was in the nature of subordinate legislation, promulgated in the exercise of its delegated power. Quasi-legislative power is exercised by administrative agencies through the promulgation of rules and regulations within the confines of the granting statute and the doctrine of non-delegation of powers flowing from the separation of the branches of the government. Particularly, the ERC applied its rule-making power as expressly granted by Republic Act Number 9136, Electric Power Industry Reform Act of 2001, or EPIRA. Rosales versus Energy Regulatory Commission, 2006, April 5. Petitioner applied for the position of RTC judge. The JBC informed the petitioner that he was not included in the list of candidates for the said stations because of the JBC's long-standing policy of opening the chance for promotion to second-level courts to, among others, incumbent judges who have served in their current position for at least 5 years. And since the petitioner has been an MTC judge for only more than a year, he was excluded from the list. Petitioner filed a petition for certiorari and prohibition with the Supreme Court, assailing the policy as unconstitutional and as having been issued with grave abuse of discretion amounting to lack or excess of jurisdiction. May the Supreme Court take cognizance of the petition for certiorari and prohibition? The answer is yes. As a rule, the special civil actions for certiorari would lie only as against judicial and quasi-judicial acts, with respect to certiorari and judicial, quasi-judicial, and ministerial acts with respect to prohibition. With respect to the Supreme Court, however, the remedies of certiorari and prohibition are broader in scope and reach, and the writ of certiorari or prohibition may be issued to correct errors of jurisdiction committed not only by a tribunal, corporation, board, or officer exercising judicial, quasi-judicial, or ministerial functions, but also to set right, undo, and restrain any act of grave abuse of discretion amounting to lack or excess of jurisdiction by any branch or instrumentality of the government, even if the latter does not exercise judicial, quasi-judicial, or ministerial functions. This application is expressly authorized by the text of the second paragraph of Section 1, Article 8 of the Constitution on the expanded judicial power of the Supreme Court. Villanueva versus Judicial Board or Judicial and Bar Council, April 7, 2005. Reyes, Council of Teachers and Staff of Colleges and Universities of the Philippines versus Secretary of Education. See also Arolo versus Aquino, July 2014, where the Supreme Court, invoking its expanded jurisdiction, said that prohibition and certiorari were proper to challenge the disbursement acceleration program and related issuances of the Department of Budget and Management implementing the DAP, notwithstanding that the same do not involve judicial, quasi-judicial, or ministerial acts. And Private Hospital Association versus Media Aldea, November 6, 2018, where it was held that certiorari and prohibition proper to challenge the constitutionality of RA 10932 or the Anti-Hospital Deposit Law, even if what was involved was legislative and not judicial, quasi-judicial, or ministerial function. Q. May the question on whether the Secretary of Justice committed grave abuse of discretion amounting to lack or excess of jurisdiction in affirming, reversing, or modifying the resolutions of prosecutors be the subject of petition for certiorari under Rule 65? Yes, even when an administrative agency does not perform a judicial, quasi-judicial, or ministerial function, the Constitution mandates the exercise of judicial review when there is an allegation of grave abuse of discretion. De Lima versus Riguera. Distinguish a petition for review on certiorari from special civil action for certiorari. It is a petition for review on certiorari is governed by Rule 45, while a special civil action for certiorari is governed by Rule 65. As to nature of proceeding, a petition for review on certiorari is a mode of appeal, while a special civil action for certiorari is an original action. As to jurisdiction, a petition for review on certiorari is under the exclusive appellate jurisdiction of the Supreme Court, while a special civil action for certiorari is under the concurrent original jurisdiction of the Supreme Court, the Court of Appeals, the Regional Trial Court, the Sandiganbayan, and the COMELEC. As to requirement of a motion for reconsideration, a petition for review on certiorari does not require the filing of a motion for reconsideration with the lower court, while the filing of a motion for reconsideration is a condition precedent to the filing of a special civil action for certiorari. So, Filing of a motion for reconsideration is a condition precedent to the filing of a special civil action for certiorari. As to regulatory period, a petition for review and certiorari should be filed within 15 days from notice of the judgment or final order being appealed from, while a special civil action for certiorari should be filed within 60 days from notice of the judgment, order, or resolution. As to findings of facts of the Court of Appeals are binding upon the Supreme Court in a petition for review and certiorari, while in a special civil action for certiorari, the findings of fact of the Supreme Court of the Court of Appeals are not binding upon the Supreme Court. As to pleading of parties, in appeal by certiorari, the lower courts or judges whose decisions are subject of review are not impleaded either as petitioners or respondents, while in a special civil action for certiorari, the court or judge whose order or proceeding are subject to challenge are impleaded as public respondents. Why is a certiorari an extraordinary remedy? Because it is only available where there is no appeal or any plain, speedy, and adequate remedy in the ordinary course of law. What is the remedy of an aggrieved party from a judgment declaring presumptive death under Article 41 of the Family Code? A special civil action for certiorari. Judgment declaring presumptive death under Article 41 of the Family Code is immediately final and executory and cannot be appealed. The remedy of the aggrieved party, then, is a special civil action for certiorari under Rule 65.